ending Australia. You're banned from Australia. Your visa's being banned. Do you want to comment? I mean, literally, it was unbelievable. And the easy answer was no. I was with my kids at Dollywood, man. I was with my toddlers, and nothing could have been more important. And but I'm going to comment on that today because the headline. This is from News.com. Tony Burke blocks visa for far-right U.S. influencer Candace Owens. He is the immigration minister, by the way, over in Australia. And I also want to make it clear to you guys that I found out at the same time that the press found out. So his office chose to leak this. This is supposed to be a private application process. So unless I spoke about this, no one should have known about this. But they chose to leak this, which I think is absolutely stunning. But listen, like I've been kind of stunned throughout this entire process, obviously, because Tony Burke, before we had even applied for a visa, said that if she applies, we're going to reject it. And I just am very interested in the process, I guess, just what goes on in this country, which is supposed to be, supposed to be a free country, I assume. But I guess the immigration minister can unilaterally make these sorts of decisions.
What's going on, everybody? This is Lady Luck here again. So that was Candace Owens giving her little spiel about the Australian immigration minister revoking her visa. So she decided that she was going to launch a legal challenge against Tony Burke in Australia. Now, as you guys know, here in the Lady Luck Club, we come with the receipts. So I have some court documents to show you guys of what has transpired so far with this legal challenge that Candace Owens has presented to the highest court in Australia regarding this visa revocation. And I want you guys to make sure you hit that like button and subscribe to the Lady Luck Club. 68% of you that are enjoying this great content are non-subscribers. So if you're enjoying this content, do Lady Luck Club a favor here and just go ahead and subscribe. You might as well. You're enjoying it. You know you're enjoying it. Hit the like button as well. And make sure you are sharing this content with others and consider becoming a member. We're going to have a members only live stream tonight. So it is going to be lots of fun. Things that I don't talk about on my main platform. You know, we get it all out in the members only. So let's get to this. What is the deal with this visa revocation with Candace Owens being kicked out of Australia? Because, you know, I mean, it's their country. They get to kick you out. But let's see what happened. So, far-right American commentator Candace Owens has launched legal action against the Australian government following the rejection of her visa. This was back in November of 2024, guys. So, it's not fairly recent, but the case is still open and pending in Australia. All right. Ms. Owens booked to tour the country for a series of shows across November, but Immigration Minister Tony Burke blocked her visit on character grounds, arguing her controversial views could potentially incite discord in society, from downplaying the impact of Holocaust comments about Mengele through to claims that Muslims started slavery. Candace Owens has the capacity to incite discord in almost every direction, Mr. Burke said when announcing his decision to knock back her visa request. Australia's national interest is best served when Candace Owens is somewhere else. So they said bye, Felicia. In a statement, a spokesman for Ms. Owens said the challenge would argue Minister Burke's decision was made with clear bias and improper motivations. I mean, all you got to do is play her videos. So I honestly don't get what her attorneys, their argument sometimes just kind of falls flat. Like our attorneys now trying to argue about the Macron's case and their motion to dismiss. You know, that motion to dismiss, Candace said on Tucker Carlson that she would not seek. Yeah, that motion to dismiss with the whole brief that had to have an extension granted to them by the court for the page and term limit. Yeah, that motion to dismiss that she said she was not going to file. Arguing that the court in Delaware does not have jurisdiction over the matter when she herself filed a lawsuit for defamation, being a public figure, in the Superior Court of Delaware against USA Today. And guess what? Candace lost. Make sure you guys check out that video on the playlist as well, because I went over that case. Yeah, no, she lost that one. Oh, man. So here we are again with another legal challenge, and it's against a country where, the prime minister said no. Now, isn't Candace Owens, being a tad bit hypocritical? A lot bit. She's being a whole lot bit hypocritical because she didn't like it when, a lawsuit was filed against her from a world leader. So when a claim comes from another country against her, all of a sudden, oh, they're impeding upon my free speech. But when she is out here filing legal actions and lawsuits against other citizens in other countries, now she's fighting for her rights somehow, as if that country doesn't have rights either. Candace, you're ridiculous, girl. So, according to Ms. Owens' legal reps, Mr. Burke displayed prejudice against her case from the onset, making public remarks that cast doubt on his impartiality long before a decision was made. I mean, Candace helped him along with that. You know why? Because all he had to do was play her videos. Play every video where she's sitting here giving commentary, saying all the things she's saying. All he had to do was watch a video. Somehow her attorneys don't know how to watch videos either. Mr. Burke also revealed private details of Ms. Owens' application to the media, further calling into question his neutrality. The spokesman said the grounds for Ms. Burke's refusal were legally unreasonable and unjustifiable. The minister's conduct suggests that this decision was aimed at boosting his public image rather than upholding a fair process. So this is from the www.news.com.au. And you guys can read more of this when you have time, but it goes into all the things that, she had said that was concerning. He's been asked to step down from any further involvement in this case. An impartial official should reconsider her application. This is why you have a legal challenge. So the legal challenge is basically her appealing the decision to revocate her visa from the entire country of Australia. The continent of Australia. It's a continent upon itself, too. Yeah. Legal challenge follows a concerted pushback from Ms. Owens across her social media channels, in which she lashed the government for what she called a petty act of vandalism. How? Okay. So I just want to get to some information here and all of the links to the articles that we're reading will be in the description of the video. Thank you guys so much for tuning in. Making sure you're hitting that like button now. So we have the Australian National Review. Okay. This came out on February 14th of 2025, as you guys can see there. Candace Owens' tour of Australia still up in the air as High Court challenge looms. So, yeah, we're going to go over some of those court documents in a second. But they're in court because Candace wants to go to court. She wants to fight this visa thing. So let's go through some of this information here on the article. And let's see why, it's still somehow up in the air and what the real fight is all about here. Because I have my opinion. Candace, I have my theory. And my theory is based on some documentation here. You create theories out of your head from, dreams and visions and bees. Mine's come from facts and documentation. All right. Her tour is still up in the air as she challenges a visa refusal by Home Affairs Minister Tony Burke in the High Court. Candace is at the center of a free speech battle, challenging the Australian government's decision to ban her from entering the country by taking her case to High Court. Why is she always stuck in a free speech battle? The Macrons have her in a free speech battle. When Donald Trump doesn't sit here and take her side, it's an issue of why you're not allowing Americans to uphold their free speech. The Australian Prime Minister has her in a free speech battle. Everybody has her in a battle except herself, even though she filed the appeal. She could go to any other continent, any other country on earth, but she'd rather just waste time, court dollars, and attorney's fees because she's paying a hell of a lot of attorney's fees on this. You all know this case is still open. All those billable hours. And yet, Candace Owens supporters are paying her attorney's fees with every cash app, with every time they fail to ask her questions and challenge her. You're shoving money her way. Why do you think she's sitting here harping on Charlie Kirk's death, getting millions of views per video? These attorney's fees are adding up, Candace. Your attorney's fees for the Macron lawsuit, that you brought upon yourself. You've got more defamation lawsuits probably coming your way as well. I heard Josh Hammer is about to make some things happen as well. We're going to go over that in a separate video. But that's going to be more attorney's fees because Candace doesn't understand the art of relaying information without being defamatory, because she's no longer asking questions. She's no longer even saying this is part of her opinion. It's as if everything is a matter of, well, this is how I feel and this is what I think it is. You know what? Brigitte Macron was born a man. That's it. That's how she comes off. And she purports this information like it's a fact. No consideration of it being, defamatory in any way. Yeah, no. And now you got all these court cases and you're having to pay all these court fees, because you brought this on yourself, Candace. So the prominent U.S. commentator was set to tour Australia in March 2024, but the Albanese government blocked her visa, citing concerns that her views could incite discord. She has not taken the case to court because she's taking the case to court, arguing that the ban is an attack on free expression and sets a dangerous precedent for political. The bad news is that we have to bump that tour to the fall, but the good news is the reason why, she said. We appealed our case to the High Court, which is essentially their Supreme Court, and we just heard back that the full bench wants to sit this, meaning the entire court, rather than us just getting a judge or getting someone to hear it. As a result of the legal fight, her tour has been postponed, but Owens remains optimistic of the outcome. So I'm just going to scroll down some on, let's see, the tour uncertainty, because I just want you all to see here, what this whole tour thing. She's always talking about somebody's hindering free speech and all this other stuff. And I will have the link to this article in the description of the video for you guys to check out as well. And you can read. I encourage that. I encourage reading here in the Lady Luck Club. Is just fundamental. Okay. So we encourage reading. So tour uncertainty. Despite the legal fight, Owens' Australian tour page still slates 5 events in Australia, including Sydney, Adelaide, Brisbane, Melbourne, and Perth, and another event planned for Auckland, New Zealand, all during March. While they are optimistic about a favorable outcome, should the appeal be denied and cancellation become necessary, we will promptly notify all ticket holders and begin processing refunds automatically on the organizer's behalf, the page states. Owens, 35, converted to Protestantism, from Protestantism to Catholicism in April 24, and her husband, George Farmer, is also a devout Catholic. I'm just trying to. Owen, she was a vocal critic of Australia's lockdown policies during the COVID-19 pandemic. Why are you worried about what they're doing in a whole nother continent, girl? Why are you worried about what's going on in the continent of Australia? Why? Is it too hard to be concerned about what's happening in the United States of America? I just, she creates these problems, goes to court, and then wants everybody to pay her attorney's fees, or sits here and talks about how it's an attack on her free speech or how they're trying to bankrupt her. You're putting yourself in this situation, Candace. Bottom line. And she also played a role in opposing BLM in U.S. Yeah, when she's focusing on the U.S., it's opposing something. Not that I don't agree with disagree with the BLM founder being charged, because she was misusing the money. But if that's all you have to focus on here in the U.S., it's sad. There are so many other topics of discussion that is occurring in the U.S. that Candace could talk about and bring some real change to, because she has a huge platform. But, when it comes to the U.S., we're just not good enough. Oh, God. All right. So aside from that, she's also been a vocal critic of the deaths in Palestine, recently attacked U.S. Donald Trump for meeting up with Israeli Prime Minister Benjamin Netanyahu, amongst many things. So let's get over to this page here. I want you all to see this. Ticket prices for Candace Owens' events in Australia range from $95 for general admission to $1,500 for a VIP package, which includes a pre-show dinner and a meet and greet with her. Tickets are available for various locations, including Sydney, Melbourne, Adelaide, and Brisbane. Do you all see how much this girl is charging for somebody to just look at her talk? Because that's what it comes down to. We're talking about a matter of her talking in front of people. She wants people to pay all of that money to hear her talk. And that's it. So this is the same person here that, I mean, she could care less about the people that are paying this money for these tickets, man. I you know, if ever you want to make a donation to the Lady Luck Club, my Cash App is scrolling below. If you're willing to spend $1,500 for a VIP package just to sit down and have a dinner with her and greet, which you really wouldn't be able to do one-on-one, but you know, okay. And then spend $100 for general admission. And this is just a general admission ticket per city. Like, it's not $95 for all 4 cities. No. Per event. This is the amount of money that she stands to lose. You all understand why she might want to keep fighting, but she's spending all of this money in attorney's fees. It is very expensive to have an attorney represent you in any international legal battle. You're talking about a legal battle going on in the highest court in Australia. Can you imagine what those attorney's fees look like per hour? How much are those billable hours for the attorneys handling an international appellate matter in the highest court in Australia? Of course, she doesn't want to cancel this event. So let's click on this, because I just want you all to see what this really looks like here. And I'm just, let's pretend like we want to, get a package. They got VIP meet and greet, VIP dinner. It's a 3-course meal, and he could even throw in a drink and dessert with that. And then of course the general tickets there. So let's find a ticket. Let's just say, just want to see what we're looking at as far as just an actual standard, pricing package here. So you see $95 reserved seating, right? Then you see this $295 for VIP meet and greet. That's just the meet and greet. That might get you another badge, a closer seat to the stage. Maybe you shake her hand, maybe you don't. And then you have this $1,500 VIP dinner, which is a 3-course meal. So, meat and 2 sides, no bread, no dessert, drink, salad. Do you get an appetizer with that? $1,500. And I want you all to look at this. This is not just necessarily for one city here. This is just overall standard how much she's charging for her tickets. $1,500 VIP dinner. How do we go from $295? To all the Candace Owens supporters out there, please help me with this mathematics. How do you go from $295 to $1,500? The only difference between the VIP meet and greet and the VIP dinner is that you get a 3-course meal. How much is the meal? You can't make this up. This girl is charging an additional what? Almost $1,300 just to have a meal with you. I mean, you only get a 3-course meal. You realize that? Of course, she doesn't want to lose this event because she doesn't want to miss out on all the money she's going to make with this. Because in my personal opinion, it's about the damn money. A 3-course meal is all you get from the VIP meet and greet to the VIP dinner is like a $1,200, a little over $1,200 difference. $1,200 difference. Not $100 or $200 difference. $1,200 difference. She's raking people over the coal here. And for what? Candace, if we want to hear you speak, we'll hear you speak for free on your podcast. Why are you charging people all this money for this? This is what you're getting here. So let's move on to the next head. Here we go. dls.hcourt.gov.au. You all, this is the High Court of Australia. Farmer v. Minister for Home Affairs. And there's a second co-defendant there. I just want to show you all the court documents here. Now, if you're looking at the date in Australia is designed to show date, month, year. Okay. So the most recent, and we're going to scroll down to the most recent activity that was done that is here on the website is May 7th, 2025. This is a transcript here, just so you all can see. This transcript of June 5th. So this summer, all right, just so you all can see here, Lady Luck Club got some court documents. I've got some receipts. Her file number is S as in Sam 160/2024. Okay. So this is a notice of filing, details of filing here. You know, when they have, it's like a court docket where you log in activity of the court docket. So if there's a hearing, then you get an activity log for a hearing. If there's, some sort of status conference, everything that happens with the case, there's a docket entry that is made to show the activity of the case. So this is just one of the things that was docketed here. And this is the transcript of a hearing that was held on June 5th of this year, 2025. So you guys can see the transcript proceedings here. Let me zoom in. I'm not going to read this because it's 104 pages long, but I'm just going to kind of scroll through it so you guys can see like the basics here. You can see it was on May 6th, 2025 at 10 a.m. Copyright in the High Court of Australia. You guys can see all of the judges here. The 1, 2, 3, 4, 5, 6, 7 High Court judges on the bench that heard this matter between Candace Owens Farmer. Now you want to use your married name. I wondered that. Why don't she use her married name? Candace Owens Farmer and as the plaintiff, and Minister for Home Affairs, first defendant, and second defendant is the Commonwealth of Australia, the whole country and continent. So you have Mr. P.D. Hirschfeld, and Mr. T.C. Smart for the plaintiff, instructed by Gillis Delaney lawyers. And then you have the Solicitor General of the Commonwealth of Australia, Mr. Donahue, and he appeared with Miss J.D. Watson and Mr. W.C.H. Randalls for the defendant. So, of course, there's the three attorneys representing the Minister for Home Affairs, the Commonwealth of Australia, and then Candace's attorneys. That is this Hirschfeld and Smart by Gillis Delaney lawyers. I believe that might be the name of the law firm, but these are the attorneys representing her. How much are you paying these two attorneys, Candace? Because they're handling an international case here that's in the damn High Court of Australia. How much are you paying them? Appellate attorneys are not cheap. You got to be paying them a hefty amount of money. And of course, the goal would be for her to get the visa to do the tour dates to make up the money she's had to pay for these attorneys. Maybe that should give you some sort of clue as to why she keeps hopping on anything that's going to get her millions of views on her videos, because she needs to generate that revenue. Because, she'll be damned if she's paying this stuff out of her pocket. Yeah, Candace, I mean your ass, girl. This is crazy. So you guys have 104 pages of this. I can leave the link to this transcript in the description of the video as well for you guys to read. Maybe get a glass of wine or something and sit down and read all of this. It's a lot. So, and I want to go back and make sure there are other documents that can be viewed. Now, for the ones that cannot be viewed here, like the order that I really want to see, this order. This was from February 10th, 25. If y'all see here, this Form 3 order, yeah, I want to see that order. Because that would have been like the first order from the court. Then I want to see this order here. Form 3 order, March 13th, 25. These are the documents I want to see. I want to see the order. And HCA is High Court of Australia. That acronym there, that is High Court of Australia. Okay. Then you have like the plaintiff and defendant filing documents here. But for where it says inspect, these are not free to view. So I just want to click on one so you all can see. I wasn't playing when I said they want you to pay. They want us to pay an considerable amount of money. Hold on a second. Let me go back. Oh, let me do the search again because it just kicked me out. You can't make this up. I think it timed out on me because I was taking too long to get to this video. Hold on one second. Okay, here we go. And okay. So let me show you all once again. I'm going to sort this by date. Okay. So we're going from earliest date to the most recent down here, May 7th. And this is the transcript. I don't know why that transcript is dated 6/5 over here. They need to correct that because the actual hearing was May 7th. Maybe this is when the transcript was completed. It probably took a month for them to complete it. So I'll just assume the hearing was done May 7th. You guys can see it's date, month, year. So May 7th, 25 is when the hearing was conducted, but the transcript probably was transcribed and posted up June 5th, 25. That's all I can take out of that. Otherwise, they need to correct that date. But I want to go up to this Form 3 order here because this is what I really want. March 13th, 25, when the highest court of Australia, gave an order. I want to see all the orders, really. I want to see this one on March 9th. I want to see the one from February 10th. But let's just click on one so you all can see. Lady Luck Club was not playing. When it says here, $33 for each hour or part thereof. How a court of Australia, y'all are tripping. If anyone has copies of those orders, please email them to me at LadyLuckClubLLC@yahoo.com, and I would be more than happy to read it. But there is no way in the hell I'm paying for $33. I don't have that type of money, y'all. Okay? I just don't. I work 2 jobs. I'm trying to take care of my kids and pay bills. I don't have that type of money to sit here and to pay out to get some a order from Australia. I just don't. This is absurd. But they have the right to, charge for it. They're not saying that you can't see it. They're just saying you got to pay for it to see it. So everything isn't free. Then you have this additional fee of $4 per page applies to download any document, inspect it. So you would have to pay the $33 fee plus $4 per page to download it. No, the devil is a lie. Okay, so let's go over. So just so you all can see that this case is in the High Court of Australia, and Candace is still racking up attorney's fees over there. Good child. Let's go to this last tab over here. So we can actually see this is on High Court of Australia for case number S160/2024, Farmer v. Minister for Home Affairs, and of course the Commonwealth of Australia. And you guys can see here's some case information. And they're giving some catchwords here: constitutional law, Migration Act. This is stuff that's cited in the court documents. Okay. where the plaintiff is a citizen of the U.S. and not a citizen or resident of Australia. Plaintiff is an internationally recognized political commentator, meaning she's a public figure. Candace, you got to stop acting as if you don't understand the concept of a public figure. Because when these defamation cases keep coming upon you hard and heavy, then it's not going to be difficult for people to prove malice intent when you keep throwing their names out there and then saying that they had something to do with someone's death. You understand what you're saying when you say those things? Or maybe not. Then you'll learn the hard way. Whatever. All right. Plaintiff applied for a temporary class activity, class GG visa, for her proposed travel to Australia, where the Minister for Home Affairs decided to refuse to grant the plaintiff the visa, relying on S as in Sam 501 6 D as in dog IV, which is 4, Roman numeral 4, of the Act in making the decision, where the minister reasonably suspects the plaintiff does not pass the character test, and that is in the national interest, to refuse to grant the plaintiff a visa. Validity, and then of course they cite the statute again, were invalid on the ground that it infringes upon the implied freedom of political communication, which is what her and her attorneys are, alleging here. They're saying that, it infringes upon the implied freedom of political communication to sit here to say you're going to deny her visa. She hasn't even came there yet and said anything, even though she's been saying all the things she's been saying in videos. And whether the minister adopted an incorrect construction of this statute here. All right. So now that you guys got the summary, let's go down to some of the documents. There's an order here on March 13th. Yeah! What does this say? Here is one of the orders. Oh, crap. Y'all, Lady Luck Club, we're awesome here. High Court of Australia notice of filing. This document was filed electronically in the High Court of Australia, March 13th, 2025. So that was the order I wanted to see. And has been accepted for filing under the High Court Rules 2004. All right, so we got the details of filing here. You can see the file number. And you see the title. Registry in Sydney. Okay, so what does it say? Come on, let's get to it. Okay, here we go. Here's an order. Look at it. So you got Candace Owens Farmer versus the Minister for Home Affairs and Commonwealth of Australia. Justice Jagged? Jagot. I hope. I know. I don't know if I want to mess that up. Special case consent. Okay. By consent, the court orders that, pursuant to R 27.08.1 of the High Court Rules 2004, the questions of law stated by the parties in the special case be referred for the opinion of the full court. Okay, unless otherwise ordered or directed, Part 44 of the High Court Rules 2004 relating to written and oral submissions apply with any necessary adaptation to this proceeding. On or before March 18, 2025, plaintiff filed and served a special case book in accordance with an index settled by the registrar. March 20th, the plaintiff filed and served the plaintiff's submission. So they're basically saying what, she filed into the case in chronology to deal with the questions of law stated in the special case. March 27th, any intervener in support of the plaintiff filed and served submissions to deal with the questions of law. April 10, defendant filed and served defendant submissions to deal with the questions of law. April 16th, this is this year, you all. Any interveners in support of the defendants or not in support of any party filed and served submissions. April 22nd, plaintiff filed and served any submissions in reply to that. So she filed some documents. The defendants filed their documents in response to that, and then she got to file a reply. And then, of course, April 23rd, the plaintiff filed and served the Joint Book of Authorities. And this was signed March 13, 25. And you see the seal and signature there. All right. So let's see what happened with that. And this is the order you all just read here. All right. So we can go from top down to the bottom. Boom, shakalaka, boom, shakalaka. There you go. So I just want you all to see this. We got the order that came on March 13th. This order here, as you guys can see, here's the case number and everything, is basically referring this case to the high court. Special case consent. So they referred it to the high court for them to make a determination on this. This is all over her getting a visa to go to someone else's country. The end. It's just all it is for her to go to another country. All right, so let's see here. Y'all, they have the on June 5th. Okay, so here's June 5th, but May 6th. I'm sorry. May 6th. I forget. Date, month, year. May 6th. May 6th. They have the hearing. They also have the video. So if you were to go on the website here, which will be in the description of the video, you will be able to click on the hearing here to take you out to the transcript, I think. And this here will take you to the actual video hearing. It was recorded. So you have an outline of oral argument by the plaintiff that was filed May 6th. Let's take a look at this. Y'all, we got court docs for days. Oh my God. Look at this. So this is basically her saying their outline for oral argument, which is what you will hear and see in that video, except this is more of a summary. Okay. So they speak on the certification, and then they speak on the meaning of Section 5016D4 of the Migration Act. They give a breakdown on that. The section means that a person does not pass the character test if, let me just zoom in so y'all can see this. This section means that a person does not pass the character test if, in the event the person were allowed to enter or remain in Australia, there is a risk that the person would cause disagreement or debate in the Australian community or in a segment of that community. There is no clear line between disagreement and debate on one hand and dissension or strife on the other. This is the plaintiff's outline for oral argument, okay? So this is Candace's attorneys making this argument. And then we're going to read the defendants. It is necessary to give Statute 501 work to do. Only Statute 501 incorporates a danger requirement. The use of the word incite does not support the defendant's construction. The legislative history indicates a deliberately broad meaning. So they're basically saying, you know, you guys are talking about she's a danger. You're not really defining, what kind of division or incite, what does incite mean in this situation? To say that there's a disagreement or debate is not necessarily a justification to say she can't get a visa. That's pretty much their argument. And then they cite other cases. There's a memorandum, kind of like an amendment or an act here in the U.S. And then they state here the fact that Statute 5016D 1 through 3 deal with apparently quite serious harms does not support the defendant's construction. Then they speak on the constitutional validity of that law. So they're trying to invalidate it. They're trying to say it doesn't really have any merit in this matter. It doesn't apply in this particular situation because she hasn't came there yet. She ain't said nothing. And never mind all the stuff she has said, it doesn't mean it's going to cause any strife or discord in Australia. But I mean, when has it not caused strife or discord? You can't make this stuff up. The validity of the minister's decision. Okay, so the minister had decided to not give her a visa, right? This is what they're appealing. They're appealing that decision where he said, nope, you can't get it. Don't care. Go throw a tantrum about it, go cry some wells. So under the assumption the defendant's construction is correct, the minister misconstrued the statute in two ways, right? The minister did not construe discord as needing to be in the nature of strife, dispute, disharmony, or dissension. The minister did not construe discord as containing a requirement of the causation of harm to the Australian community or a segment thereof such that the persons represent a danger to that community. They didn't really get into detail, according to the plaintiff, as to how she's going to somehow bring about strife or discord or dissension or some sort of debate or harmony or danger. How does she disrupt the harmony? How does that happen? I mean, all they have to do is play all her videos. All right, and then relief they're seeking, in addition to the other relief sought by the plaintiff, the court should issue a writ of perambulatory mandamus if Statute 501 is invalid. So if it's invalid, then the court should issue a writ of perambulatory mandamus. All right. So let's go to see what the outline of the argument was from the defendant. So we're going to scroll down here. You guys see here the case information, Form 27F, defendant's outline or argument. And this was on May 6th. This was filed on May 6th. The hearings, I think, was May 5th. And you guys can see the case information there. So they start with propositions to be advanced in the oral argument, proper construction of incite discord. So they're basically saying a risk that a person would incite discord does not refer merely to causing disagreement or debate. It refers to the risk that the person would stir up strife or dissension in the Australian community or a segment of it of a kind that involves harm to that community or segment. So they're saying, we're not just saying that she's going to create some sort of disagreement here. No. She's going to create the type of disagreement that can become dangerous. So when she's out attacking Jewish people, she's putting Jewish people's lives in danger because of her rhetoric. That's what they mean. And then they're saying all her videos is sitting here attacking people by their ethnicity or by their religion, and she doesn't care about the backlash of it because Candace Owens can't control her base. And there are some crazy people that support her. And she can't say that these people aren't going to go out and do harmful, dangerous things in her name. Just like when she was sitting here talking about Phil Lyman, where's his mother, who's the nephew, cousin, and then that man had to delete all his social media because people were harassing him online. He didn't have a moment's peace. So it's not exactly her telling people to go and do things. It's the fact that the things that she says incites people to want to do dangerous things to whomever she's targeting. And that's absolutely correct, because I have been speaking on the dangers of Candace Owens' accusations trying to connect innocent people to Charlie Kirk's death. And her base is incited by going out and looking for these people, researching all these people, like Phil Lyman and his family, simply because she put their name out there and said, I found it very suspicious and odd that he would want to retrace the steps of the killer. Why does he have so much interest in this? Like no one else can be interested in what happened to Charlie Kirk. Candace, you are not his only friend. You weren't even the only woman in his life. He had a whole wife. But this is what she does in every situation. So it's not just this case where that could be easily proven. But they could use the other examples of how she induces this cyber harassment online because she's just putting out people's names. Josh Hammer is thinking about filing something against her. I mean, to the point where people want to file defamation lawsuits. Brigitte Macron, the First Lady of France. She's tied up in litigation matters that prove the point that they're trying to make in Australia. You incite people to do dangerous things. Your words could be defamatory. It could cause great harm and danger to our community, especially a particular segment of that community, i.e. the Jewish community. Now, do you all see how this goes? Sometimes it just takes a little breaking down and understanding and then being able to correlate other examples into the equation. So, of course, they speak to context. They give more case law. They give some sort of history. The Lim 5 has its origin in Para C of the public interest criteria previously found in the migration regulations. The paragraph was interpreted by the federal court to include the conduct now addressed in limbs is like sections 3 through 4, and not to extend to mere disagreement or debate. And then they cite case law here. Y'all decide they cite their case law. All right, so that's a case. That's a case. Here's another case. And you're welcome. Then they give other sections of that statute 5016 to kind of support it. So they're saying it's not deliberately broader than the paragraphs in this section here. It basically comes down to this. You represent a danger to the Australian community based on other factors that are being met in that same statute. And then there are case law to support how that same law was interpreted in other cases. The implied freedom of political communication. There's a burden for that. Statute 5016D4 does not burden the implied freedom for two reasons. It does not burden any right or liberty arising independently of the act. Without a visa, an alien, because you see he's an alien there. Candace, you're an alien in Australia, okay? You don't have to be over there. God, that's funny. First, it does not burden any right or liberty arising independently of the act. Without a visa, an alien has no right or liberty to enter Australia. Is that enough said? Without a visa, an alien from outer space has no right or liberty to enter Australia. Candace, you don't have the right or liberty to enter Australia without that visa. Okay? They don't have to let you over there. Even if you ask nicely, how do you make up for all the harmful things you've said about particular sections of a community? Like the Jewish community. You keep harping on them. Section 501 is one of the provisions of the Migration Act, which define when an alien will be granted a visa to enter Australia. Okay? The plaintiff's attempt to establish a burden by asserting that she has a right to a visa, but for statute 5016D4 is foreclosed by unchallenged authority. So her attempt in saying I have the right to get a visa there because reasons does not fit under this statute. You can say whatever you want, but just like with the Macrons, Lady Macron does not have to give you any blood, Candace. You're the one accusing her of being born a man. Why does she owe you DNA to prove your point? Her burden will be to prove that she is a woman and that you lied. The end. They don't owe you anything for that. They've given her exhibits and documents, and she just doesn't want to accept it. The court will not care about that, Candace. Just like here, you're trying to establish a burden by asserting that you have the right to a visa. That's not what this statute speaks to. It doesn't say anything about you having, just because you believe you have the right to get a visa to go to Australia, does not mean that your political communication is being, somehow challenged or restricted. No one's silencing your free speech because you think that you have the right to get a visa there. And they said no. Bye, girl. Bye, Felicia. Bye, Felicia. Section 5016D4 does not burden the liberty of Australian citizens and residents to engage in political communications with each other or with aliens who are in Australia or who are located overseas. They keep calling you an alien, Candace, because they want you to know that you're an alien. Because you don't live there and you don't belong there. You see how that feels? Doesn't feel good when there's another country calling you an alien, does it? It does not burden the liberty of Australian citizens and residents to engage in that political communication with each other or with aliens who are in Australia or who are located overseas. The implied freedom, being a restriction on legislative power, confers no right upon any person to require an alien to be granted permission to enter Australia to engage in political discussions here. So in other words, this implied freedom you have here, okay? Everybody has the right to say what they want to say. It doesn't confer any right upon someone to be granted a visa or any permission to enter Australia to engage in those political discussions. You can say what you want to say, but it doesn't mean we have to give you a visa to come to our country. Those are two different things. You're trying to say they're not giving me a visa, therefore they're infringing upon my freedom of political commentation. No, they're not. They're saying you can say what the hell you want to say, but it doesn't mean that you should be automatically granted the right to come to Australia. Those are two separate matters. So no one is restricting upon your implied freedom, to have political discussions here. But it doesn't mean that you don't have the right to be granted permission to enter Australia. You can't make this up. Well said. Secondly, this statute, section 501(6)(d)(4) is a definitional provision. Even when read with a statute 501(3)(a), it imposes no burden unless the discretion is exercised to refuse an alien permission to enter Australia. Oh man, it imposes no burden unless the discretion is exercised to refuse an alien permission to enter Australia. There's no burden that's imposed based on that section. It basically just kind of defines what that provision is. It defines that statute. All right. It has nothing to do with, imposing some burden unless it is specifically dealing with, and you're talking about them having the discretion to grant you a visa. So that's what they're saying here. The refusal of an alien to come to our country, it has nothing to do with how this provision is to be defined. We're simply saying here, you can't imply that your right to do anything is being restricted or that there's some undue burden. Because we're telling you, based on this statute here, we have the discretion that we can exercise to not grant you a visa. You're an alien and you don't have to come to our country. If that provision is not valid in all its operations, it must be read down or partially disapplied so as to permit only those exercises of discretion that are within constitutional limits. And then they have case law here. Alternatively, any burden arising from statute 501(6)(d)(4) is slight. At most, it imposes some limits on the manner in which a small subset of political communication can occur. Justification: if the defendant's construction of a statute 501(6)(d)(4) is adopted, it is readily seen to be reasonably appropriate and adapted to the legitimate purpose identified. And then they have DS42, the plaintiff's submission that an obvious and compelling alternative to this statute is reverting to the initial risk threshold cannot be accepted because a provision in that form would not achieve Parliament's purpose to the same or a similar extent. Further, the provision is adequate in its balance, for any burden is so slight that it cannot manifestly outweigh its legitimate purpose. So the burden that you're implying here does not outweigh the overall purpose of what that statute serves. The end. Let's see here. I want to make sure I just get down to the bottom. The minister did not misconstrue the statute. The minister did not use the term incite discord to refer merely to disagreement or debate. He found there to be a risk that the plaintiff's expression of her views in Australia would amplify grievances among communities and lead to increased hostility and violent or radical action because Candace cannot control her base. Where is he lying? Candace cannot control her base. So he's not lying in this. He's telling the truth. So this is where we are, people. So the grievances that, let's say, the Jewish community will have in Australia would be amplified because they fear that based on the things that she said already and the things that she would say in Australia would lead to increased hostility and violent or radical action. Because she already has 5 million plus people on her YouTube channel that are supporting her every word she says. They don't even question. So we can't say the communities that are already reaching out to us saying we don't want her here because we don't need that nonsense. You can't say that that would not be amplified if she were to come here and then buckle down and double down on the things that she's saying, especially when she's targeting certain communities. And the people listening to her, how do you know they won't go out and do violent stuff? They've already been incited to, do cyber harassment and cyber stalking, cyber bullying. These people fear for their lives. They believe that if she comes here and she incites them even more in person now, they're going to go to those communities and do some nonsense that would incur violence and hostility and radical action. And we can't have that. That is the risk of discord that was found to engage Statute 50164. Nor did the minister equate discord and harm. So, peremptory mandamus should not issue if Statute 50164 is invalid. If it's invalid, the minister is under an enforceable duty to make a decision under Statute 65, but there is no basis upon which the court should order the minister to grant a visa. The material before the court does not establish the plaintiff either passes the other limbs of the character test or satisfies PIC 4001 and indeed suggests otherwise. Neither plaintiff, and they cite case law here, nor the matters relied in PS 66 provide any support for such relief. So basically, there's no basis to which this court should be ordering the minister to grant a visa to her. Not under this statute. There's no, what legal, basis can you give to say, based on this particular statute that he used to say, I'm not granting it, where in that same statute should the court order him, the minister, to grant her a visa? That is the legal argument here. So, y'all, this is something else. And let's go back to this tab here. And as you all can see, October 15, 2025, judgment summary will be provided. So today is October 11, 2025. So in 4 days, so that's Tuesday. Is that Tuesday? Yep. Today is the 11th, tomorrow's the 12th. No, that's Wednesday. 13th is Monday, 14th Tuesday, 15th. October 15th, we should see an update from the High Court of Australia regarding some judgment or judgment summary. And we will be looking out for that, as well as doing an update on her lawsuit against that the Macrons have filed against her. So we're looking out for this stuff, y'all. And I have another case I want to go over when it comes to Candace Owens because, she's a hypocrite and all. And she acts as if she doesn't know how court works. But yet, Candace, you're filing all of these appeals to the highest court in Australia. And for what? They're not obligated to give you a visa. And you're going to have to give back refunds because no one should be paying $1,500 to have a dinner with you. That's absolutely absurd. Now, if people want to be dumb enough to pay that type of money, whatever. But you could be buying anything else. Why don't you just donate to the Lady Luck Club because you want to. But should you choose to not financially support, hitting that like button is free. Subscribing is free to do. Commenting in the comment section is free to do. So I encourage you all to do all three of those things. Hit the like button, subscribe, and let me know your thoughts in the comment section. Let me know what you think the judgment summary is going to be on Wednesday, October 15th in the year of our Lord 2025. Thank you all so much for listening in. Make sure you check the description of the video for the links for all of the documents that I have presented today in this video, plus the Dr. Squash products that are tagged. We have a partnership with him here in the Lady Luck Club. And yes, I do receive a commission on the sales. So go buy some Dr. Squash soap, deodorant, toiletries for your loved ones. Christmas will be soon around the corner, so you can just buy some Dr. Squash soap products and just put it in the stockings for the stocking stuffers. Yeah. And make sure you give a shout out. All right. Thank you so much for tuning in. I appreciate all of you here in the LLC and all of your support. And until the next one, Lady Luck Club out. Deuces.